A courtroom in Oakland, California. 8 jurors, parents in the gallery, who buried children they say Instagram helped kill. And on the other side of the room, lawyers for one of the most valuable companies on earth. This isn't a settlement hearing. This isn't a fine getting quietly paid and forgotten. This is a full federal trial, and the number on the table is almost too large to say out loud. $1.4 trillion. Not million, trillion. That's close to Meta's entire market value, sitting on one verdict. 29 states, Republican and Democrat, red and blue, are arguing that Mark Zuckerberg's company built Instagram to be addictive on purpose, that it knew the damage being done to teenagers, measured it internally, and kept shipping the product anyway. Meta says that's not true. Meta says it built safety tools, spent billions on trust and safety, and did everything a responsible company could do. By the end of this video, you'll understand exactly how this case was built, the whistleblower testimony that started it, the trillion-dollar math behind the number 1.4 trillion, and the twist that could turn this trial into the blueprint for regulating every AI company in Silicon Valley. Stick around, because segment 4 is about a court order that doesn't just fine Meta, it tries to delete part of what Meta has built. To understand what's actually being argued in Oakland, you have to go back to September 2021, when the Wall Street Journal began publishing something called the Facebook Files. The documents came from a former Facebook product manager named Frances Haugen, who had quietly copied tens of thousands of internal pages before leaving the company. In October 2021, she testified in front of the US Senate, and what she described wasn't a company that didn't know its products caused harm. It was a company that had run the numbers itself. Internal research, Haugen told lawmakers, showed that Instagram made body image issues worse for 1 in 3 teenage girls. Internal slides showed the company understood that its recommendation systems could pull vulnerable teenagers deeper into content about self-harm and eating disorders, the more they engaged with it. And instead of redesigning the system, the documents suggested the company debated how to talk about the problem publicly. Haugen's core argument was simple, and it's the argument that now sits at the very center of the Oakland trial. Meta had a choice between user safety and user engagement. And every single time, it chose engagement, because engagement is the entire revenue model. More scrolling means more ads seen. More ads seen means more revenue. A teenager who can't put the app down isn't a bug in the system. To the state's lawyers, it's the system working exactly as designed. 2 years after Haugen's testimony, in October 2023, a coalition of attorneys general filed suit against Meta. It started with 41 states and the District of Columbia, later narrowing procedurally, but keeping 29 states as the core coalition carrying the case to trial. The complaint makes 4 specific legal claims, and each one is doing very different work. First, that Meta deployed manipulative design features, infinite scroll, autoplay, algorithmically timed push notifications, specifically engineered to maximize time on app among users who are legally minors. Second, that Meta publicly represented its platforms as safe for teenagers, while its own internal research said otherwise, which the states argue is a deceptive business practice under consumer protection law. Third, that Meta violated the Children's Online Privacy Protection Act, COPPA, by knowingly collecting personal data from children under 13 without verified parental consent, at scale, for years. And fourth, that Meta had specific knowledge of the psychological harm being documented internally, and chose not to act on it in any way that would meaningfully reduce engagement. What makes this coalition unusual is that it crossed party lines almost completely. California and New Jersey attorneys general sit on the same legal team as attorneys general from states with very different politics. In American litigation, that kind of unanimity almost never happens. It happened here because politically, protect children from a tech platform turned out to be one of the only issues left that both parties could stand behind, in the exact same courtroom. The trial itself began on August 18, 2026, in the U.S. District Court for the Northern District of California in Oakland. 4 states, California, Colorado, Kentucky, and New Jersey, are leading the litigation on behalf of the full 29-state coalition, presenting the case to an 8-person jury. State attorneys opened by walking jurors through internal meta-communications, arguing the documents show executives were repeatedly warned by their own researchers and chose the version of the product that kept users online longer. Parents of children who died by suicide sat in the gallery during opening statements, a detail multiple outlets covering the trial specifically noted, because it signals exactly what kind of testimony is coming. Meta's defense opened with a very different story. Its lawyers argued the company has invested heavily in safety infrastructure, age verification systems, parental supervision tools, content restrictions for minors, and that correlation between social media use and teen mental health struggles is not the same as proof of causation. Millions of teenagers use Instagram, the defense argues, and the overwhelming majority do not develop serious mental health conditions. The trial is expected to run roughly 6 to 8 weeks, with testimony expected from Meta CEO Mark Zuckerberg, Instagram head Adam Mosseri, and top safety engineers. The jury's verdict will be advisory. A federal judge makes the final ruling. But an 8-person jury openly siding with the states would carry enormous weight going into that decision. Here's where the case stops being just another regulatory fight and becomes something almost unprecedented in corporate litigation. The states aren't only asking for financial penalties, they're seeking civil penalties that could total as much as $1.4 trillion under state consumer protection statutes that allow per-violation fines multiplied across millions of underage accounts. It's a ceiling, not a guaranteed outcome. But it's the ceiling that's making headlines because it's a number that rivals the company's entire valuation. But the financial penalty may not even be the part Meta fears most. The states are also seeking structural remedies, mandated age verification systems, restrictions on addictive design features like infinite scroll for minors, and, if the jury and judge find Meta violated COPPA specifically, an order requiring Meta to delete all data it collected from children under 13. Not just the data. The complaint goes further than that. It asks the court to require Meta to delete the algorithms and AI models that were trained using that improperly collected data. Sit with that for a second. This isn't a fine that gets paid out of a marketing budget. For a company whose next decade of growth depends almost entirely on AI systems trained on enormous pools of user data, an order to delete AI models built on unlawfully obtained information would be closer to a forced surgical removal of core infrastructure than a settlement. This Oakland trial isn't happening in isolation. It's the biggest fight in a much longer war Meta has been losing pieces of for years. In New Mexico, a state investigation used undercover accounts posing as children to document how predators contacted those accounts on Meta's platforms and how the company responded. A judge later ordered Meta to pay $567 million toward teen mental health programs in that state. In Los Angeles, a jury ordered Meta and Google to pay $6 million to a young woman who said she'd become addicted to Instagram and YouTube as a child, in one of the first individual verdicts of its kind against the platforms. And in Nashville, Tennessee, a parallel state case against Instagram is on trial right now, running roughly in tandem with Oakland. None of these cases alone would threaten Meta's core business, but taken together, they form a pattern that plaintiffs' attorneys are actively citing in the Oakland trial. A pattern of prior findings, prior settlements, and prior admissions that make it much harder for Meta's lawyers to argue this is the first time anyone has raised these concerns. Here's the part almost nobody covering this trial is connecting. And it's the reason this case matters, even if you've never opened Instagram in your life. The legal theory the states are using, that a product was deceptively designed to be addictive and that the company knew the harm and hid it, is not unique to social media. It's the exact legal framework now being used in early lawsuits against AI companion apps, AI chatbots, and AI-driven recommendation engines. If a jury and a federal judge accept that engineered for addiction is a legally actionable design choice, not just a business strategy, but a form of consumer harm, that ruling becomes a precedent. And every AI company racing to build systems that learn your emotional patterns, remember your conversations, and keep you coming back is watching this exact courtroom to see where that legal line ends up getting drawn. This trial was filed as a case about children and social media, but the verdict, whichever way it goes, is going to be read by every AI company in Silicon Valley as an early answer to a question they're all quietly asking. How much of what we're building right now would survive this same argument in court? Meta built an empire on attention, one scroll at a time over more than a decade. Now, for the first time, a jury in Oakland gets to decide whether that empire was built on harm, and a federal judge gets to decide what happens next. Whatever the outcome, this trial has already done something no settlement ever could. It's forced the exact playbook Silicon Valley uses to build addictive products out into open court, on the record, for everyone to see. Corporate power isn't just built in boardroom deals, it's tested in federal courtrooms. This is Corporate Docket. Subscribe, and we'll see you in the next case.